Houston. He specializes in constitutional law, the Supreme Court, and the intersection of law and technology. He is the author of several books, including Unprecedented, The Constitutional Challenge to Obamacare, Unraveled, Obamacare, Religious Liberty and Executive Power, and most recently, An Introduction to Constitutional Law, 100 Supreme Court Cases That Everyone Should Know, which I understand from following you on Twitter, Josh, is doing quite well. So congratulations on that.
Thank you.
Professor Blackman was also selected by Forbes magazine for the 30 under 30 in law and policy. He's twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and healthcare. He's also an adjunct scholar at the Cato Institute and is the founder and president of the Harlan Institute, the founder of Fantasy SCOTUS, the internet's premier Supreme Court fantasy league, and he blogs at joshblackman.com. And has also authored over 36 law review articles, and his commentary has appeared in the New York Times, the Wall Street Journal, the Washington Post, USA Today, the LA Times, and other national publications. So Josh will speak to us today about the revised makeup of the Supreme Court and the current legal challenge to Obamacare. And I think, Josh, hopefully anything else that folks want to hear your opinion on, which hopefully will be a lot, and so I'll turn it over to you.
Thank you so much, William. It's a pleasure to be here in Brooklyn. I'm from Staten Island. Usually, if I was at Brooklyn Law School, my parents would be there watching in the crowd, but they're not. They're on YouTube now, so they'll see this eventually. I'd like to talk a bit about the Roberts Court and where it's headed, and specifically what it's going to do with the Affordable Care Act case, which was argued 2 days ago. So this is a very timely recap of the argument. All right, so let's just take a step back. The Roberts Court formed in earnest nearly 15 years ago when Chief Justice Roberts replaced William Rehnquist as the chief. And then Justice Alito replaced Sandra Day O'Connor on the court. And that move seemed to shift the court to the right. And we didn't really know where the Roberts Court was headed till 2012. We got NFIB versus Sebelius, the Affordable Care Act case. This was a challenge to the ACA. A number of conservative groups argued that Congress lacked the power to force people to buy health insurance. 5 justices agreed. And the court held that Congress could not command people through its commerce power to buy insurance. But then another group of 5 justices held, well, perhaps we can read the ACA differently. The ACA raises revenue. That revenue is paid to the IRS. And in many regards, the ACA looks like it's imposing a tax. So it's not the best reading of the statute, but it's a permissible reading of the statute. And in light of the so-called saving construction, we can read the ACA as giving people a choice between purchasing health insurance or paying a tax. And that is a choice Congress can impose. Now, that's not what Congress actually enacted, but that reading was permissible because the ACA raised revenue. Okay. Fast forward to 2017. President Trump and his administration try to repeal Obamacare. They fail. John McCain gave a big old thumbs down. But Congress was able to pass a tax reform bill. And part of the tax reform bill modified the ACA. It didn't touch the mandate. But the ACA did modify the penalty. The ACA reduced the penalty from about $700 a year to $0 a year. It didn't repeal the penalty, it just changed the amount to $0.00. As a result, people who now fail to maintain insurance would have to pay a grand total of $0 to the IRS, which is nothing. You don't have to pay anything. At the time, I thought, look at that. By dropping the penalty to 0, the saving construction no longer holds. Why? Well, the only reason why the ACA construed as a choice was because it resembled a tax. And now it's not raising revenue. It doesn't resemble a tax anymore. Okay. Well, Texas comes along and sues the United States. And private individuals sue the United States as well. And they've argued that because the mandate is now unconstitutional, the rest of the ACA has to fall. And that's the challenge we have in California against Texas. Now, why is this case called California against Texas? Well, the Trump administration decided to agree with Texas. They decided that they would not defend the ACA. Basically, both now the Trump administration and Texas agree that at least some parts, perhaps most, maybe even all parts of the ACA are unconstitutional. The district court ruled basically that the entire ACA has to go. The Fifth Circuit Court of Appeals ruled, well, the mandate's unconstitutional, but we need more fact-finding to decide how much the law has to be set aside. And I should note that both courts cited my work. I don't get much credit for that, but at least maybe this crowd will get some emoji applause, right? There, thank you.
I would have mentioned it if I knew.
It's okay. Well, it's better not to put that in my bio because people don't like it very much.
The New York Times article about it neglected to mention that for some reason.
It's okay. Fake news. I demand a recount. No, I'm sorry. Too soon. We need observers to watch it. All right. So here we are. The Supreme Court heard arguments on Tuesday. And let me try and run down what happened because there's a lot of stuff going on. The first item I want to discuss is actually the bench. When this case was being briefed over the summer, we had 9 justices, and Justice Ruth Bader Ginsburg was the 9th justice. And it looked like, once again, that John Roberts would be the swing vote, that whatever majority opinion would have to go right through his chambers. But then, as we know, in September, Justice Ginsburg passed away, tragically. And she was replaced by Justice Amy Coney Barrett, who is far to her right. So now, the 5-4 breakdown that we thought would decide a case is not there. There are other possible breakdowns with the court. Now, that doesn't mean Texas wins automatically, but it's harder for the plaintiffs to prevail with Justice Barrett. So it's harder for the ACA to survive in its entirety, or at least in part, with Justice Barrett, although I don't think that's going to happen for reasons I'll talk about later. All right, so the 3 major issues here that are very closely intertwined. The first issue is what's called standing. The second issue is what's called the merits question. Is the mandate constitutional? And the third issue is what's called severability. If the mandate is unconstitutional, what about the rest of the statute? Usually in litigation, you approach the case sequentially. You first do the standing, right? Are the parties injured by this law? Then you consider the merits. Okay, is this provision unconstitutional? And then third, you talk about severability. Okay, this provision is unconstitutional. What other parts of the law have to fall as well? This case flips that analysis. It's almost topsy-turvy. And let me explain why. The only reason that this case matters is because of the severability argument. If the mandate can be severed, that is separated from the rest of the ACA, then this case doesn't amount to much. In the very end, the court might say that the mandate's unconstitutional, but the rest of the law stands. And the world will look exactly the same it does today, except for professors like me who are like, okay, good, the mandate's unconstitutional, right? I'll be happy, but no one else will. All right. But if the mandate is severable, that is, you can separate the mandate from the rest of the statute, then the standing analysis becomes very messy. Why? Because how do you issue an injunction to enjoin a provision that's not being enforced? Right? I think there's an injury. I'm with you there. But generally, to have standing, you have to have some sort of redressability, some sort of traceability. You can issue an injunction to someone to stop it. Right? So the standing inquiry turns on the severability analysis. In other words, if the mandate is inseverable for purposes of standing, you can proceed to the merits. But if you don't assume that the mandate is severable for purposes of standing, then the case gets a lot harder. So it's very, very messy, this case, right? The justices were sort of flipping around of what's the correct sequence to resolve this case in. All right, so let's take standing one at a time. I think there are 3 possible ways the court can resolve standing, right? The first way the court could resolve standing would be to say neither party has standing, that the private plaintiffs have no standing because they're not being forced to pay anything, and the state of Texas has no standing because they're not subject to the mandate at all. They have to do other stuff under the ACA. I think the private parties are injured, and I've put an amicus brief to that effect, but let's just assume the court goes down this path. Neither party has standing. Does that mean the ACA is safe? No, not necessarily. Justice Alito, who he continues to impress me. He's so unassuming. He's not very flashy, but he's just asked the best questions. And if you ever want to see a judge asking painful questions, just listen to Alito. He had this entire thing gamed out. He brought his A game for this one. Justice Alito asked a few questions, and he basically said, oh, I think I'm frozen. No, I'm good. Justice Alito asked, what would happen if the federal government prosecuted someone for violating the ACA? Imagine someone commits Medicaid fraud, right? They rip off the government. And the government says, okay, we are going to charge you with violating the ACA. And then the defendant says, oh, really? Guess what? Obamacare is unconstitutional. Because the mandate's unconstitutional, it can't be severed. At that point, the court would have to adjudicate, is Obamacare constitutional? So what Alito is basically saying is, let's say the court punts and just dismisses the case on standing grounds. This case doesn't go away. It just comes back in a few months or a year with someone who absolutely has standing because they're being prosecuted by the government. So I put a blog post up in the Vol Conspiracy this morning, or 3 a.m. this morning, whenever I go to sleep, I don't even know anymore, right? Saying if the court punts here, they don't get rid of the case. And of course, I know standing is jurisdictional, can't be waived, but the court often will say, well, we don't need to decide this, it's just not important. I think we need a resolution on this issue. Every month that this is lingering is a month where people are in jeopardy. So I think there's a cause of concern to simply dismiss the case on standing ground. All right. The second standing argument concerns the states, Texas. Here's what Texas argues. Ready? The IRS requires Texas to submit reports, right? The ACA says, Texas, you have to put these reports to the IRS. And those reports involve information of people who are buying insurance because of Obamacare, right? So again, ACA says, people, you must buy insurance. Okay. You must be insured. Okay, then people gain insurance because of the mandate. And then in turn, Texas has to report those numbers to the government. So at some small level, the ACA's mandate is causing Texas to do work. It's causing them to complete forms. And forms don't fill themselves out. It takes money to fill out forms. All right. So Texas says, our injury flows from the mandate. And we have a pocketbook injury we're paying to complete these forms. The challenge for Texas is that they are not being injured by the mandate directly. The mandate doesn't apply to them. It applies to people. So their argument is one layer removed. But at least Texas has a traditional pocketbook injury. Okay. The third possible standing ruling is involving the individual plaintiffs. They argue that the mandate by itself is affecting an injury. And I submitted a brief saying they're right. The requirement to buy insurance is itself an injury. It's making you buy healthcare you don't want. It doesn't matter if there's a penalty. The mandate itself is self-executing. It causes the injury. But the challenge for the private plaintiffs was articulated by Justice Barrett very well. She's going to be good, guys. I am so happy with her so far. I mean, it's only 2 weeks, but so far so good. I'm very optimistic. Barrett asked a question. She says, how can you actually get a remedy, right? You sued various federal officials. How is your injury traceable to those officials? The injury you're claiming is based on what insurance companies are doing, right? It's not because of what these people are doing, that policies are unavailable. So I think the way to thread that needle is by bringing in severability. Generally, when you're talking about standing, the court assumes the facts of a well-pleaded complaint are true, right? You say, if these complaints are true, if the allegations are true, is there a plausible claim for relief, right? Is there a basis for jurisdiction? You basically assume it. You can later find that the facts were not true, but for the jurisdictional analysis, you basically assume the you assume the premise of the complaint. And the premise of the complaint is that the mandate cannot be severed from the rest of the ACA. If the court assumes that's true, then when you're discussing traceability, you're not limited only to the mandate. You can consider the broader ACA of how it does injure the plaintiffs and how the injury can be traced to the federal officials enforcing the law. I'm going to spell this on a blog post later today, so you're getting the preview. It's just my head's sort of spinning. But I think that's the answer to Justice Barrett's question, which wasn't obvious. And I don't think the lawyers quite answered it the way I would have. But the thing is, I can blog. No one stops me from doing it. It's called virtual briefing. It's very effective. Where after a case is argued, all these law professors write blog posts saying, "Here's what people should have said." The lawyers hate it because they can't do it, but we can. What the hell? I have tenure. It's true. So I think the standing analysis is enough to clear the hurdle. I think the court will find either Texas has standing because of this sort of injury derivative to the mandate, or they'll find that the individuals have standing by using this assumption of inseverability. And I think that might work. Query, though, just for a minute, what if you have a very funny fracture, right? What if you have 9 justices, 3 justices say that the states have standing, 3 justices say the individual plaintiffs have standing, and then 3 justices say that no party has standing? What do you do with that? How do you add that up? Because there are 6 justices who say that the private parties have no standing, and there are 6 justices who say that the states have no standing. But what if it doesn't line it that way? What if they don't say anything else? What if you have 3 and 3? Okay, well, a majority says they're standing, you go forward. I think the court would have to resolve that internally. I don't think we can do that. The court will have to figure out what the hell the standing analysis is. But I think the 3-3-3 split is not crazy. And let me just explain why. Let's say the court adopts a very broad standing ruling for the states. Okay, all the red states are going to be very happy with that. They won't say it out loud, but then they can sue Biden for the next 4 years on broad standing theories. So by giving the conservative states this broad ruling on state standing, you're basically opening up the door to suing Biden. We have to switch sides again. Now red states will sue a Democratic president. Everyone sort of just flips around. It'll just, this happens every 4 to 8 years. I'm used to it by now. Okay. That is the standing question. Let me go on to the merits issue. Right? The merits issue, I think, are simpler, although it could be messy. In NFIB, the court held that Congress can't force people to buy insurance. But they said, we can construe the statute as giving people a choice, not a mandate, a choice, because it raises revenue. But the law no longer raises revenue. Right? So what's the basis for the statute? Now, the government has basically come up with a creative argument to defend. They said, well, we don't have to rely on the commerce power. We can rely on the taxing power. We say, well, Congress decided that they don't want to charge a tax now, but maybe they'll charge a tax later. And that's a valid thing for Congress to do. They can say we can charge a tax later. And I think that's too broad. If the argument is you can do whatever you want now because you can impose a tax later, Congress has basically limited powers. It's a general police power. So I don't think that works. So if the court finds they're standing, I don't see how they uphold this section. I think they declare the mandate unconstitutional. But then the fun part comes with severability. Now, I'm sure you've seen a million headlines in every single newspaper saying, will the court strike down all of Obamacare? Give me a break. It's not going to happen. It's not going to happen. This is, pardon my politics, it's fear-mongering, right? This is very effective Democratic messaging that's just been absorbed everywhere. And let me give you law why it's not going to happen. In the best case scenario, the court's most conservative members, Clarence Thomas and Neil Gorsuch, do not favor severability doctrine. Justices Thomas and Gorsuch, our most conservative members, I think at least, have said, we do not have the power to strike down entire statutes. All we can do is issue specific remedies in the case to address specific injuries. So even before Obamacare came around, right, before this case came to the docket, Thomas and Gorsuch were on record that we do not strike down entire statutes. There were never, ever, 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 ever 5 votes for complete invalidation. Just there weren't. There were not 5 votes for it. Texas knows this, right? I'm sure if you ask these people over a beer behind a face mask, they'll tell you, right? There's not 5 votes for this. I guess you put a straw through. No, you can't do that, right? I've seen people do that. They put a hole in their mask and they drink through a straw. Crazy thing, I saw a guy playing a clarinet with a special mask. He had a special mask that went over his clarinet. It was the things we think of now. So they're not 5 votes for this. And last term, in a case called Barr versus AAPC, American Association of Political Consultants, Justice Kavanaugh wrote this opinion where he basically said, look, we have to be surgeons. We take a scalpel and just remove out the bad part and pluck it away. So we all knew this, right? This was not a mystery. This was not a mystery what was going on here. We knew this was going to happen. During the arguments, Justice Kavanaugh, Justices Roberts, were very adamant saying, we're not going to kill this entire law, right? Justice Barrett had a similar comment. So 20 million people committees, Obamacare is not going anywhere. The best case scenario for Texas is that the court says the mandate's unconstitutional, and that's it. We go home. I'll take that as a victory, because that will mean that my reading of the Obamacare decision was correct, that there was a mandate, and it's no longer a mandate. The court could also hold that there's no standing, which I think would simply punt, and it will come back to the court really quickly. Or the court could say, this is the funniest one, which the Solicitor General sort of suggested. We can say, well, we're just going to decide the severability question. We're not even going to decide the standing or the merits. We'll say because the Obamacare mandate is severable, because the mandate is severable, we just get rid of the case, right? There's no injury because you can separate the mandate. They could actually basically just skip from step 1 to step 3 and go right to severability. That would be crazy, but it would actually be the least messy. So I think that's a possibility. You could just skip standing, skip merits, and go right to severability, which I think would be frustrating AF to teach, but that's my life. That's what John Roberts gives me. I give him lemons, he gives me lemonade. That seems every term happens. That will come in June. Now, let me pivot back to the court. I think given the current breakup of the Senate, which will either be 50-50 or 52-48 Republican or 51-49 Republican, there's no appetite for court packing now. Thank God. I was worried about that for a while. It might come back in 2 years, but I think it's unlikely. This is something that you really need the first 2 years of her presidency. I'm assuming, I don't think Biden will have some momentum in 2 years to pull this off. So court packing is off the table for now. We'll have these 6 justices for a while, and I think we're going to see how they shape. I am very optimistic of Justice Barrett. I'm not playing. She's sharp. Her questions were extremely good, both in the Fulton case, was a free exercise case last week, about a Philadelphia adoption agency, or a foster care program in Philadelphia. And her questions are sharp in the Obamacare case. So I am very optimistic. And, every court takes on a life of its own. You can't predict how a court will vote in any given case with new members. The dynamics are always different. I think what will end up happening now is that Roberts realizes he can't be the kingmaker anymore, right? He's not the middle of the court. The middle is probably Kavanaugh at this juncture. I think Roberts will have to moderate to the right. That makes sense. He'll basically have to vote with the conservatives so he's not in dissent. I don't think the chief wants to spend the rest of his career in dissent. I don't think he does. I can't think in American history of a great chief justice who was in dissent all the time. So I think Roberts would rather be in the majority rather than be in dissent. And that's going to force him to basically play with Amy, play with Brett, play with Anil, play with Clarence, get along with them. And I think that means that Justice Kagan's influence wanes, and she's going to be bitter about it. She was ticked off in the arguments yesterday. I think or Tuesday. She was ticked off because she was arguing that how dare you try to reconsider NFIB? That case was settled, right? How dare you try to argue NFIB said something it didn't say? And she just seemed, how dare the Solicitor General make these crazy arguments? She just seemed pissed, and I think she recognizes her influence is on the wane. She will not be able to pull the chief like she used to. If anything, I think Justice Barrett will have a much bigger sway. I think of Justice Barrett as like Justice Scalia with a good personality, right? Scalia just pissed people off and alienated people. Barrett has the chops, but I think she will be a much more effective member of the court and not alienate people. Just her background, the way she raises her kids, and with faculty governance, just her persona just radiates this. Just like, okay, we'll have a talk. Whereas Scalia would just throw bombs at people all the time. I've read a lot of Barrett's opinions in the Seventh Circuit. She doesn't take cheap shots. She could, but she doesn't. Even when the other side takes cheap shots at her, she doesn't fire back. which I think is hard, right? You're all in law school, you know this works. Someone comes at you, you want to come back at them twice as hard. And it's sometimes better not to, and just to let things ride, to sort of just let things go along. And I think it's more effective in the end. All right, I'm at half an hour now. I'll stop. I do welcome your questions, and I hope I can talk about any other topic you want to discuss. So thank you all so much.
Thank you. That was great. I guess I have one question. Actually, you know what? Does anyone else have a question before I ask? If not, then no, we got something in the chat here.
Oh, yeah, let me put the chat on. What does he say? Okay, Jason. Is Barrett an originalist or a textualist? You know, I think she said she's an originalist. I have no reason to doubt her. I think all of her opinions I've read so far are consistent with originalism. Also, she had a lengthy career as a professor where she wrote about textualism, she wrote about canons of construction. She's given these issues a lot of thought. This is not someone who just sort of woke up one day and wanted to be a judge. She's been thinking about these issues for a very long time, and I'm very optimistic.
So I have a quick question about, you said there were 3 different categories of people that we have to think about with standing. For the individual not being able to, or being forced to purchase a certain kind of healthcare, how is that concrete and particularized, like as far as that first prong goes? So
there's so let me be very careful. With the individual plaintiffs, right, there's 2 types of injuries, right? In the brief I filed, the injury they assert is the mandate by itself, right? The mandate says you have to buy insurance. And that's the same injury that was raised in 2012 in NFIB. NFIB was not about a challenge to the mandate and the penalty together. It was about the mandate by itself. And as I read NFIB, the mandate by itself was causing an injury. Now, it's unusual, right? How can a statute without a penalty cause an injury? But such a statute is rare. Justice Kavanaugh made this point, I think, quite well. If you flip to the U.S. Code, you don't have mandates without penalties. Congress just never enacts those laws because they don't work very well. This law is, in regards, unprecedented, the title of my first book. So I think the mandate by itself would be enough to cause an injury. Okay, but there's another argument they raise, that it's not just the mandate causes an injury, the mandate causes them to buy a policy that they don't want. Right? They want to buy a cheap policy, but because of Obamacare, they can't. Therefore, the pocketbook injury is purchasing a policy they don't want. Right? But to make this second argument work, you need inseverability. You have to say that the injury is not just from the mandate, but the mandate combined with this entire unconstitutional law. Right? So you need inseverability to make the second standing argument work. Right? My brief focuses on the first standing argument, which I think could work just by itself. Right? But the second argument, you need to bake in inseverability. Does that make sense? It's a very good question, and I'm going to be writing a blog post about it probably the next few hours. So, people watching on YouTube, you'll see it soon.
Does anyone else have any questions? And I think you probably field questions about other,
whatever you want. Open book, guys. You guys are on Zoom all day. You get the business, whatever you need.
Yeah, I have a quick question.
Oh no, go ahead.
Yeah, so I think it's pretty timely with the pandemic and, the resulting economic impact. How, I don't know if this was raised in oral arguments or whether what you think the Biden administration is going to do to push what they believe is lack of responsiveness to the pandemic to kind of suggest bolder executive action and further proponenting the ACA in full.
Yeah, I mean, look, so you're asking about what sorts of executive action that Biden will take. What we've seen in the last, 15 years or so is that when a president lacks the majority in Congress, he turns to the pen and phone. We saw this with President Obama, we saw it with President Trump, and now we're seeing it with President Biden. I think the most immediate space we'll see executive action concerns COVID. I think he will try to impose various types of mandates on states and people for wearing masks and otherwise. I don't think he has the power to mandate a mask mandate. He suggests that he can impose a mandate on people using interstate travel. That might be okay for airplanes. I don't think it reaches things like private vehicles. I think that's perhaps too far. if you're just driving down the LIE, right, you're in one state, or the BQE, you're not in the ambit of federal regulation that goes too far. If you can just regulate anyone in a private car who's driving on an interstate highway. I think in some regards we're going to see some executive action on I don't know about the elections. I think that Congress really has to intervene. Although I suppose with election law, the Department of Justice can bring enforcement actions under Section 2 of the Voting Rights Act. Right? They can basically allege that the various conservative districts have engaged in voter suppression. They've racially gerrymandered. They've done different things. The Voting Rights Division has been kind of a sleepy the last couple of years. I think we'll see a ramp up of that. We'll probably see a lot more civil rights prosecutions for LGBT issues. We still have the litigation of the Little Sisters of the Poor and the contraceptive mandate. We have the Title IX litigation about school bathrooms and athletics. We have the affirmative action litigation where schools are, using racial preferences. So there are a lot of areas where the Biden administration will take positions that are opposite what Trump would have taken. Thank you. Very good question.
I think this is one that probably everyone's thinking about. But let's say that they're counting ballots after a certain time in Pennsylvania, or poll watchers aren't able to get into Detroit, where they're counting ballots. Things are happening in Arizona and Georgia. What happens in the current, Supreme Court if these sort of like voter fraud or irregularity cases make it there?
Yeah, look, I know I'm getting this question quite a lot. I don't think the court even takes any of these cases. I think the Supreme Court is just going to say, this is not close. We're not intervening. Let the lower courts decide, and they're going to call it a day. There's no obligation for the court to take a case. I don't think they do. I've given interviews on dozens of radio and TV networks. From what I've seen, the sorts of things that President Trump is alleging are not enough to flip the election. Even if everything he says is true, right? The margin of victory of Biden is simply too great. And at some point, I think Trump will realize that this is not going to work, but he's doing it for show, right? He's doing it to keep people happy that he's fighting till the end. I think at some point, he'll leave the White House. I don't know when, but he'll leave. Maybe before January 20th, and maybe head down to Mar-a-Lago for a nice New Year's vacation. It's extended. And come January 20th, Mike Pence will swear in. John Roberts will swear in Joe Biden. And that'll be it. And then we'll move on. I know in the moment, things always seem crazy and hectic, but if we take a step back, things move pretty smoothly, right? The election was smoother than I thought. I thought it'd be a lot more messy. And things were actually, pretty smooth. I see there's a question in the chat about the expansion and contraction of government powers over quarantine. Yeah, so I'm happy to talk about that. I actually, I sued Governor Cuomo again, right? I sued him a couple times, but I recently sued him on behalf of a Jewish school in Brooklyn. It's in Queens, it's in Far Rockaway. Over one of his orders shutting down schools in predominantly Jewish neighborhoods. And that case sort of fizzled out because the government keeps changing his orders every couple of days, it seems. But at a high level, I think we need to have a very careful conversation about the government's emergency powers. There's some old decisions from the early 20th century which involve quarantine and inoculation. And those cases are not good fits for the modern Free Exercise Clause jurisprudence. Chief Justice John Roberts wrote an opinion saying, well, we're not going to intervene. And that came, I think it was in June, that decision, or maybe end of May. And now here we are, almost December. And this pandemic keeps going on and on and on and on and on. And we have these, these orders that seem ad hoc that are issued every other day for who knows how long. I think state legislatures need to take a very close look at authority given to the governors. I think there's too much power. There's no accountability. There's no explanation. They can just do whatever they want when they need. I think a legislature should be much more careful in giving such vast authority. So, for example, instead of letting the governor decide on a whim what businesses are and are not essential, let the legislature decide that, right? Maybe the legislature could prioritize some things over others. right? In some states, houses of worship were deemed essential. In other states, they weren't. In some states, gun stores were deemed essential. In other states, they weren't. In some states, abortion clinics were deemed essential. In other states, they weren't, right? These are things that should be decided by the legislature, not by the courts, and not by the governor. So I hope, God willing, this pandemic comes to an end soon. May we speedily in our time not wear masks all day. But when that does, state governments, be very careful to reassess how much power, because these sorts of pandemics may spring up again, and we should not be caught flat-footed like we were in March, where we freaked out, we shut down borders, we locked people in their houses, right? We enacted all these measures that were utterly, that were in hindsight not very smart, right? We said, oh, don't wear masks. People don't wear masks. Save it for the professionals, and that was a disastrous decision. There were a lot of mistakes were made with the nursing homes. Just so many mistakes, top to bottom. I think we need to really think about how we give governors as much discretion to just make it up as they go along.
I'm sorry, an additional question to tack onto that. How do they decide that this is a pandemic or that this is a quarantine? What's to say, what if this is 1 in 10 million people will die and everyone else is fine versus, 1 in 2 people, or, what if there's one case in the entire United States, or what if there's 100 million? What's to stop, some governor being like, no, look, there's still a couple thousand people in some different part of the state. This is still a quarantine. I still have all these expanded powers. And is the alternative giving it to the CDC or some agency that's putting a lot of power in the hands of a few bureaucrats. So,
look, I think the legislature can create what we might call a trigger, right? It says, if this infection rate is present, this happens. If this infection rate is present, that happens, right? You can actually try to figure out the various levels of dangerousness of diseases. And of course, it's always hard to decide what how to measure an infection rate. Is it a rolling average, a 24 average, right? Is it what's the asymptomatic rate? I'm open to different suggestions, but there has to be some trigger of when these powers vest, so it's not to be abused too greatly.
So I can, you mentioned affirmative action before. I think it was this morning, the First Circuit declined to overrule the district court's ruling. I can't remember what the most recent Supreme Court case was, where Sandra Day O'Connor said, we might revisit this in 25 years. Yeah. Do you think the court is likely to take this case up? And if they are, what do you think they're going to do with it?
Reverse. Look, I actually taught affirmative action in class yesterday and Wednesday, and I'll tell you what I told my students. Of all the precedents on the court's docket that are most likely to overruled, I think it's affirmative action. The court's last statement of affirmative action came in 2016, a case called Fisher. Fisher versus University of Texas at Austin. So you had Abby Fisher, a white girl, challenged UT's policy. The court split 4-3 and upheld it. 4-3. How 4-3? Kagan recused and Scalia had died. So there was a 4-member court. Guess what, folks? Four votes is not a majority precedent. It's not precedent. It's not. It isn't. I think the court says no Fisher, and then they'll say they go back to O'Connor's Grutter decision in the Michigan case, but they're actually going to overrule it. I think the court is going to clamp down on Harvard. The amount of evidence in there, I think, is enough to make the court say we're not allowing this to happen. And keep in mind, Harvard is a private school. It's not a public school, right? The private schools are bound by Title VI of the Civil Rights Act, right, which limits discrimination in education. So I think the court's going to say that these sort of, not quite quota, but these very explicit uses of race are not sufficiently tailored. That I think is going to happen the next year or so. With Justice Barrett, I think it's almost a given, right? If I was Elena Kagan, I'd be worried right now because there's nothing to stop this, right? In 2016, after Scalia died and the court sort of punted on the Texas case, Ginsburg gave an interview, which he shouldn't have done, but she said, you know what? I think our affirmative action cases are safe for now, right? And she was very wrong because she thought Garland would replace Scalia, and then that Hillary Clinton would put 2 more justices in the court. So of all the areas of the court's jurisprudence that are on the chopping block, I'd say affirmative action's there. Abortion probably too, maybe torture is a word for chopping block, but I think the abortion case is probably also on the docket for a revision. Maybe some admin doctrines also, but I think once we have a Democratic president, John Roberts will be a little bit less afraid of ruling, in terms of, I don't want to be like a Trump fan. I think he'll be a little bit more unencumbered in some regards, especially now that court packing's off the table for a while. I think it's dead. I think it had there been a blue wave and the Dems had 54, 55 senators, I think they would have done it. I think now, just with a 50-50 split, there's no way they get it done. Right? I mean, they want to make District of Columbia a state, Puerto Rico a state, basically radically alter. I think all that stuff's off the table. I can't see it getting done.
One can hope.
Well, maybe, I don't know. I'm usually pretty pessimistic, but I mean, to nuke the filibuster with a VP breaking the tie, I just don't see that happening. That's really risky.
So on the affirmative action point, what do you see? Let's assume that everything breaks the way that you think it's going to. What do you see these schools doing?
Lying.
Like, do you think Harvard could possibly?
They'll just pretend to do something else. Right. Look.
Figure out some other way, which is basically, I think, probably what they're doing now.
Of course.
I mean, you kind of alluded to. They're letting in a very consistent number of Asian students every year, despite the fact that they're saying, "Oh no, it's not a quota." And of course, we only factor that in as one point. But clearly, if you let in, somewhere between 29 and 30% Asian students, like, you're obviously doing something resembling a quota.
Look, I'm dating myself, right? But I was in college in 2003. You were probably old in elementary school, right? I was in college in 2003 when the Michigan case came up. And I had a professor, and she basically said in class, I'll never forget, she said, yeah, it doesn't really matter what the Supreme Court does here. We'll find a way to admit minority students, right? They'll just lie. They'll find another way to do it. Indeed, Justice Ginsburg wrote a dissent, I guess it was a concurrence in the Michigan case, where she said, let's stop with the charade, right? Let's stop forcing these schools to make up crap and just let them do what they're going to do anyway, right? Let's just give them deference. And that's what the Fisher case said. We're going to defer to the schools to let them run their own affairs. That might be a good policy, but that's not strict scrutiny, right? If you want to water down strict scrutiny, you can do it, but don't pretend there's a strict scrutiny. Don't give deference there, because that's not how deference works. So I think the court will simply say, no, you have to use diversity as one of many factors in the schools, create these elaborate studies that do exactly what they're doing now, just with a more, with a fancier patina of credibility. So nothing will change. I mean, that's one of the things about litigation, right? No matter what you do, people don't actually change. Things seldom stay the same way they are, right? I'm sorry. Things usually stay the same way they are. That's trying how things go.
I think we have time for one more question. If no one else has one, then I have a quick one.
Sure.
I don't know how quick it is, but something that's very important to me is the Second Amendment. Do you see expansions onto the DC v. Heller or McDonald? I know that I've been following Judge Benitez out of one of the districts in California, who's doing really great things. Do you envision anything happening in the maybe not so distant future that would be beneficial to the Second Amendment?
Yeah, Heller was decided after my second year of law school, and I was all excited. And that was now 12 years ago, and nothing's really happened since. For the longest time, I wondered, is it Justice Kennedy who's holding up the Second Amendment? And now I actually think it was Roberts. Roberts doesn't like change. He likes everything to be the same it was in 1982. Just whatever it was in 82, that he clerked the year. That was like the peak of human civilization. Just Reagan was in office, everything was just great. Whatever mattered in 82 is what matters. If it didn't matter in 82, he just doesn't care about it, right? So just like the world is frozen in 1982 for young John Roberts. I'm mostly being sarcastic. I don't think the Second Amendment was ever very important to him. I just don't think he ever cared. And we know, but there's been leaks from the court to various reporters who suggested that Roberts didn't want to take another gun case. He said, all right, well, you guys, if you take this gun case, I'll rule against the Second Amendment. Guess what? He ain't the fifth vote anymore. The notorious, or perhaps the glorious ACB has written very strongly in the Second Amendment. She had panel opinion on the Seventh Circuit that was stellar. I mean, she just nailed it. The text and history, she really did a good job. It was about a person who had been convicted of some sort of stupid white-collar offense, some sort of Medicaid fraud. I can't remember the specifics. Right? Why is a person who commits a stupid white-collar offense forever barred from owning a gun? Right? He's not violent. It was just committed fraud. And showed this very strong opinion saying there's no tradition of banning people for these white-collar offenses. They pose no risk to others. So I think we'll get a gun case in the docket, and I think there are going to be 4 votes to take it, and we'll see if John Roberts is willing to be in dissent on this one. So it might be a carry case. It might be a case about capacity magazines. It might be a case about permitting requirements. I don't know what the case is. There are a lot of different vehicles that could work. It could even be a case about restoration of felon rights, which is sort of this left-right issue that's not a clear conservative cut. Red flag laws, I don't think there'll be red flag laws, Jason. Sorry. Those are too controversial. But I think it might be a felon disenfranchisement case. If I was them, that'd be a smart one. But I think we'll get a Second Amendment case next year or two. It won't be revolutionary, but we might get something.
There was that New York City case, I think it was last year.
Yeah.
That really irritated me that the court let the city get away with that.
Yeah, don't remind me. Yeah, that one sucked.
Yeah.
Look, that was the New York pistol and rifle case where basically New York happily defended its law all the way through the court systems. And the second certiorari was granted, they basically burned the law in acid and they buried it underneath the Meadowlands with Jimmy Hoffa, and they can never get it back. And it's gone forever. I can tell the joke in New York. Can't do that elsewhere, right? It's gone. So they mooted the case out, which I think was correct. But the upshot of this is, I think Kavanaugh was pissed, right? Kavanaugh had this separate writing where he said, well, we're going to dismiss this New York case, but there are all these other great cases in the docket. And then a month later, they got denied. So Brett got played. I think Brett was pissed. He actually joined the Thomas dissent on the Rogers case from New Jersey. So I think we have 4 votes for a grant. I just don't know which case it's going to be. And we'll see if the chief is really willing to be in dissent on this. I'm sure he could do it, but I think he might want to be in a majority to control where the opinion goes. I mean, it's also possible that the court says, you know what, Roberts, you can concur. We don't agree with your opinion. Your moderation is no longer needed. And he will realize how quickly he'll be relegated if he doesn't play ball. We'll see.
Yeah, I remember, I think it was, I guess it must have been before Ginsburg passed away. You wrote a very interesting article about John Roberts being in dissent that effectively was giving Kagan so much more sway in the court.
Yeah, I think that's gone now. Kagan had a good run with the chief of just sort of this playing nice, but I think those dynamics now are altered. Also, Justice Breyer, I mean, he's probably going to retire soon. Assuming that there's a Democratic president, he may not be on the court next year. He may step down soon. We don't know. And that modifies the dynamics also. So I think Breyer and Kagan had a good relationship with John Roberts. Whoever replaces Breyer, I think Kagan will be by herself. I mean, Sotomayor is there, but she's not there to play ball. She likes writing her dissents, and she writes vigorously dissenting. So I think the dynamics of the court changed so much when RBG was replaced by ACB. It was perhaps the most significant change on the court in decades, maybe since Thurgood Marshall was replaced by Clarence Thomas. I mean, this is the most significant shift from one to the next. But even then, I think is even greater because Marshall he was towards the tail end of his career. He didn't have as much influence as he once did.
All right. I think we're nearing the end. I don't know if you have any plugs, if you want to plug your Parler account or.
I'm not on Parler, so you can at me. I won't even see it. I don't have to plug anything. If you want to buy my Introduction to Con Law book, you should. It's an excellent book. Con Law students love it, but I'll leave it there.
All right. Let's thank our speaker. I think it was a really great virtual event.
Thank you so much, everyone.
Hopefully we could do something again in the future.
I open back in Brooklyn next year, so I can go see my parents, and I'll be happy to have them come along.
If we're all in person again, we'd love to have
God willing. Your lips to God's ears. Thank you so much, everyone.
All right, thank you so much.
Thanks, everybody.
Thanks, Josh.
Thank you.
Thank you for coming.
Thank you.